Good afternoon, friends. Important judgment from Madras High Court. Whether recommendation of GST Council can be relied upon for passing any judgment or ruling. We have seen that as and when GST Council meeting held, lot of recommendation made by GST Council. Whether such recommendation can be relied upon unless there is proper amendment made by notification. Even circular will not work. GST Council ने रिकमेंडेशन दिया और एक सर्कुलर इशू हो गया for clarification. But there is no corresponding change in the law by way of amendment in the act or through a notification. Important question. In one of the case, Parle Agro Private Limited, advance ruling which was made in the case of Britannia Industries Limited was challenged before Honorable Madras High Court. And on the basis of recommendation made by GST Council, this ruling was passed that flavored milk, which is falling under tariff heading 0420 GST rate 5%, going to fall under beverages containing milk 2202 tariff heading, and GST rate would be 12%. GST काउंसिल के रिकमेंडेशन के बेसिस पे उन्हें फ्लेवर्ड मिल्क को कहा ये बेवरेजेस कंटेनिंग मिल्क टैरिफ हेडिंग 2202 एट द रेट ऑफ 12% में फॉल करेगा, जबकि एक्चुअली ये होना चाहिए 0420 एट द रेट ऑफ 5%. क्वेश्चन यही है कि क्या आप जीएसटी काउंसिल के रिकमेंडेशन के बेसिस पे क्लासिफिकेशन डिसाइड कर सकते हैं? And Honorable Madras High Court has categorically said no, it can't be. The recommendation made by GST Council is only recommendatory. You must be recalling Honorable Supreme Court judgment in the case of Mohit Mineral case. GST Council can make recommendation, but this is only recommendatory. It is not compulsory unless there is proper amendment in the act or through a notification. Even circular cannot take a position. Circular for clarification for the recommendation of GST Council may be held ultra vires unless there is corresponding change. That is what Madras High Court has said. I'm drawing your reference here, the explanation Roman 3 and Roman 4. Under GST goods rate notification 1/2017, important. We all know that tariff heading, HSN code for the goods. If your aggregate turnover is up to 5 crore, then we are following 4-digit HSN code effective from 1st April 2021. If registered person aggregate turnover is more than 5 crore, then it is 6-digit. We all know about it. Up to 5 crore only for B2B supply and B2C optional, but more than 5 crore with a B2B or B2C 6-digit compulsory. But when we look at Custom Tariff Act, first schedule Custom Tariff Act, HSN is being provided in 8-digit. So whenever you are having any classification dispute of goods, This explanation, Roman 3 and Roman 4 of GST goods rate notification 1/2017 going to play important role. What Roman 3 says, Roman 3 explanation. Subheading, tariff item, heading. These items which is being given in the first schedule of Custom Tariff Act 1975 shall be applicable pari materia even for the heading, subheading, tariff item classification for GST goods classification for determining tariff heading under the GST regime. If you are having any doubt, you can very well look at heading, subheading, tariff item classification as per first schedule of Custom Tariff Act 1975 shall be applicable even for the interpretation of goods rate notification. Explanation 4 of this goods rate notification says, rule for interpretation for first schedule of Custom Tariff Act, including section note and chapter note. These are pari materia even for the goods rate notification. Importantly, so whenever we are having any doubt for determining classification and corresponding HSN code in GST regime, because we are mentioning only 4-digit for registered person having aggregate turnover up to 5 crore in the past. If aggregate turnover more than 5 crore, then 6-digit. There may be and lot many point would be there where classification dispute persists. We must go back to this explanation Roman 3 and Roman 4, which is pari materia and shall be applicable even for interpretation of goods rate notification. Just to highlight here some of the important and boiling point which is coming to my mind while recording this video. Ice cream parlor. What is the rate applicable? 5% as a restaurant or 18%? Lot of dispute in the past. Come to that cattle feed and poultry feed. Tariff heading 2302, 2303, 2309. Ingredients, raw material which is being used for making cattle feed or poultry feed exempted hai under tariff heading 2309. It is falling under rate notification, also falling under GST exemption notification also 2/2017. When it is exempted, when it is taxable, lot of dispute and circular comes in. They are saying cattle feed or poultry feed per se exempted, but ingredients used, wheat bran for making cattle feed, ingredients chargeable at the rate of 5%. Why such dispute? Another one, if any parts and components used for manufacturing of finished goods, and these parts and components are specifically used for manufacturing of finished goods, then quite obvious these parts and components going to fall under the same tariff heading wherein this finished goods is there. That is what we have seen in number of section and chapter notes, general rule of interpretation. But we have seen the litigation and dispute persist. Ballpoint pen, important one. Dispute in the past we have seen. And still, we have seen for the past period this dispute is persisting. Only from 1st October 2021 they have given little clarity. But why such dispute when explanation Roman 3 and Roman 4 categorically saying that we are going to rely first schedule to Custom Tariff Act? But the recommendation of GST Council is not binding to determine classification in terms of Article 279A to the Constitution of India. And that is what this Madras High Court judgment in the case of Parle Agro Private Limited. A detailed newsletter is being given in the description box, which you can download and run through for ease of your reference. Thanks for watching. Stay tuned. Thank you very much.